Hello, everyone. The focus of this lecture podcast is on the separation of powers principle, and we will see its operation both at the level of the Federation or the Commonwealth as well as at the level of the states, and then the interaction of the concept of separation of powers between the federal powers and state powers. So we're going to examine that as well. So at the end of this lecture podcast, you should be able to distinguish and explain the operation of separation of powers at the federal and state levels, and then explain the weakening of the division of powers between the legislature and the executive, and the permissibility of vesting quasi-legislative powers on the executive. Explain as well the guardedness of the High Court against any encroachment into federal judicial powers. Should also be able to explain the concept of judicial power in relation to the High Court's strong resistance against the vesting of non-judicial powers on Chapter 3 courts, and then cite and discuss key judicial decisions that elaborate on the separation of powers. So let's begin by talking about the three types of government powers. If we look at the Australian Constitution, we will see that the Constitution itself actually clearly delineates and identifies the three types of government powers. These are legislative, executive, and judicial. So Section 76, Section 1 of the Australian Constitution provides that legislative powers is or lies with the federal parliament or the Commonwealth Parliament. Executive power obviously also lies under Section 61 with the executive branch of the government. And in that case, when we speak of the executive government, it is quite clear under Section 61 of the Constitution that that power is vested actually in the Queen and is exercisable by the Governor General as the Queen's representative. So there is that fiction, if you look at Section 61, that it is the Queen that is the executive, and that it is the Governor General as the Queen's representative who is the one who exercises the executive powers. But in truth, or in reality, as we saw in previous lectures, executive power is actually exercised by the Prime Minister and his cabinet, or the cabinet ministers. So while there are certain executive powers which may be exercised by the Governor General, when we speak of executive powers, as we saw before, the executive power actually is exercised by the Prime Minister and his cabinet ministers. Under Section 71 of the Constitution, judicial power is with the Chapter 3 courts, or the federal courts. And the federal courts, obviously, in that case, as we will later see, does not just consist of the federal courts themselves, whether it's the High Court of Australia or the Federal Court of Australia or the Federal Circuit Court of Australia or the Family Court. In fact, Supreme Courts of states may actually be vested and often are vested with federal powers as well. Now, the one thing that is important to emphasize is that, or maybe to ask, is what would have happened if, assuming that we had a unitary system of government in Australia, in the sense that you didn't have the federation and you didn't have the states. And for that reason, there was no written constitution. So I make that point quite clear because the main reason why you might say that there exists a written Australian constitution is that it was imperative for the states, when they federated themselves into the Australian Commonwealth, it was necessary for there to be a written constitution that would delineate the powers of the federal government as opposed to the powers of the state parliaments. Now, so the question is, what would have happened if in Australia there were no written constitution, which would then delineate the three types of government powers? Or what would then happen in states such as the UK or New Zealand, where there is no written constitution? Does it mean, therefore, that government powers don't exist? Or does it mean, therefore, that there is a lot of blurring of lines of government powers, so that it is possible for a single government body to exercise these three types of powers of being of legislative, executive, and judicial powers. And it should be apparent to you by now as we go through the week 4 topic, and as you've gone through the lecture podcasts and lecture notes or if you've read the book, the textbook, in the first 3 weeks, you would have realized that if you speak of a democracy, and we look at the notion of constitutionalism and the notion of constitutional government, even in the absence of a written constitution, and this is true in the case of the UK and the case of New Zealand, it is not possible for a single government body or single government agency or a single instrumentality or a single person who represents the government to have all three types of government powers, meaning it's not possible for a single entity to have legislative, executive, and judicial powers. Because if that were so, that person can then enact laws or legislate laws and then execute the laws, and then in exercising the judicial power, it will be up to that person to then determine whether those laws or the execution of those laws are legal or valid. If that were true, that single entity would be easily described either as a dictatorship or a despot or an autocrat. And you cannot have it you clearly cannot have it in a true democracy. And as we know, if you look at examples of totalitarian states, and a perfect example might be the case of North Korea, Kim Jong-un, or probably his father, Kim Jong-il, and so on. That single person, Kim Jong-un, who is actually the head of government, he is the head of the executive government of North Korea. He has the power to pass laws, and he's actually the judiciary himself. And you will have read stories of him just determining that the chief of staff of his military or some of the government minister can just be subjected to firing squad. In fact, there were stories of incidents of a key government minister who fell asleep in one of his meetings, and he decided to actually use a missile to kill that government minister, to have the government minister killed because out of disrespect. So that is a clear example of a totalitarian state where all the powers of a government are in a single person, and that, as we know, is quite dangerous. And there are still some countries today, fewer countries now, where you have a dictatorship where, although in principle there might appear to be three different bodies of government, you have the legislature, you have the head of government as the executive, obviously, and then you have the judiciary. In truth, the legislature and the judiciary happen to become instruments of the executive because they are afraid of the powers of the executive because they could get killed or they could get imprisoned. And in that case, in reality, there is really no delineation of these three types of government powers. But in a true democracy, where constitutionalism or a constitutional government exists, even in the absence of a written constitution, such as in the case of New Zealand and the UK, these three types of government powers exist, and they are separate from each other. Now, as you've also noticed, if you speak of Westminster parliamentary types of government, there is in fact a blurring of the lines of the legislative and executive powers, mainly because, as we know, the Prime Minister and the members of his cabinet, meaning the cabinet ministers, are also part of the federal parliament. And so in that case, you will see that there's a clear blurring of lines of the legislative and executive powers because the executive are actually in a position to determine what the legislative agenda should be, and they actually determine clearly to a great extent what laws ought to be passed by Parliament, because it is the Prime Minister, who is in a position to control or to determine the legislative agenda because he has the support of Parliament. And we know as well that there is a blurring of the lines because in that sense, it's actually possible for the legislature to state that it has lost the confidence in the Prime Minister and cause the Prime Minister to resign. So that should be clear. Now, I also wish to point out, because I earlier stated that there is no written constitution in New Zealand. Let me just clarify as well, on that point, that whilst there is no written constitution that is this in the same that has the same character as the Australian Constitution, in the case of Australia, you have the Australian Commonwealth Constitution, which is the fundamental of the land. New Zealand actually has a written constitution. It calls itself the New Zealand Constitution, but it does not have the same character of supremacy over other laws in New Zealand. So whilst there may be a written New Zealand Constitution in name, actually it is treated just like any other piece of legislation, meaning it can easily be, not really easily, but it can be amended by an act of parliament without the need for the people to get involved. And it is not fundamental in the sense that in the case of New Zealand, even if that exists, it is permissible. It is not permissible for New Zealand courts to state or to make a finding that the laws of parliament are invalid. So if they can, New Zealand courts cannot declare a law passed by parliament to be unconstitutional or invalid. And that's because of the principle of parliamentary supremacy in New Zealand, or parliamentary sovereignty, in the sense that anything that not really anything, but in general, whatever the New Zealand Parliament passes, and they have a unicameral parliamentary system in New Zealand, whatever the New Zealand Parliament passes is considered to be valid, and the courts in New Zealand are powerless to declare such a piece of legislation to be unconstitutional, which is obviously quite different from the case of Australia, where the High Court and federal courts have the power to declare laws passed by Parliament to be unconstitutional and invalid. So hopefully that's clear enough. Now, moving on. So we're gonna what we intend to do in this lecture podcast is to provide some a broad overview at this point on the three types of government powers. So we will try to provide more background on legislative powers, executive powers, and judicial powers. And in the succeeding weeks, or in the coming weeks, we will try to dig deeper and examine in greater detail these three types of powers. But for the purpose of this lecture podcast, it's essentially just giving a broad stroke on these three types of government powers. So let's speak of the legislative powers. So there are five key aspects to the legislative power, and at this point, as I said, we're just talking about it in a broad detail. One is the competence to create and promulgate new relations, rules, and rights. And what that essentially means, if you compare that to a judicial power, as we will later see, the judicial power can only be invoked or can only be triggered when there is an actual controversy. And in that case, the judiciary is reliant on existing rules. And the judiciary cannot create new legal relations between persons. On the other hand, when you speak of legislative powers, for example, even in the absence of an actual controversy, even in the absence of a legal controversy, it can actually create new legal relations, rules, and rights that affect persons. And as you know, that's the very nature of Parliament passing laws. And so Parliament can pass laws on crime, enforcement of rights, privileges and remedies, imposition of liabilities, and so on, even in the absence of an actual controversy. Secondly, the other thing that we have to realize is that as far as legislative powers are concerned, they are actually plenary and complete, in the sense that it is an axiom of constitutional law that a sovereign nation has the power to pass any law that it wishes that is applicable within its own territorial limits. And in other words, in that case, the power of a legislature, for example, subject to the Constitution in the case of Australia, to legislate cannot be controlled by an external power. So in other words, the United Nations, for example, or any other country, whether it's the United States or any other country for that matter, cannot limit or constrain the uh, the the power of the legislature to enact laws. And that is crucial because at some point we will encounter instances later on where the executive may enter into a treaty, and the treaty may actually provide for certain duties that, in a sense, delimit the scope of legislative power. So it could be about the environment, it could be about the proliferation of nuclear weapons, it could be about how to sanction terrorism. I mean, not sanction terrorism, but how to combat terrorism. And the point there is that even if the executive government enters into treaties which somehow delimit the scope of what laws can be passed in Australia, those treaties by themselves, as we will later see, do not form part of Australian laws. They may have a persuasive effect, but they are not binding until such time as the federal parliament actually passes legislation that makes the provisions of that treaty as part of Australian law. So the existence of a treaty by itself do not become part of Australian law. They are only part of Australian law when Parliament passes legislation adopting whatever is in the treaty to become part of Australian law. So in other words, again, that is a crucial point because there might be efforts, for example, on the part of some parties to say that because Australia is a signatory to this specific treaty, which might be about global warming and so on, or about the environment, or about international crimes. Therefore, that specific person or that specific party may then try to invoke those specific treaties or international instruments as a way of seeking rights in Australia. And it should be made clear that unless and until the Australian Parliament adopts, under what is known as the adoption or incorporation principle of international law, adopts those treaties or its provisions, they do not become part of Australian law and are not binding in Australia. Now, although we know that it's plenary and complete, meaning it can pass any law that it wishes, and as I said, it cannot be controlled by any external instrument. There are obviously constraints, especially in Australia, and those constraints are based on specific constitutional provisions such as the principle of the separation of powers and the division of federal and state powers. And we will later see as we go into this lecture podcast, and as you've probably read through the lecture notes and gone through the textbook, if you speak of the federal parliament, for example, the power of the federal parliament to legislate is specifically limited to what is provided in the Constitution. So beyond what is provided in the Constitution, for example, under sections 51 and section 52, the Commonwealth Parliament cannot legislate outside of the scope of the clear provisions of section 51. So, in other words, unlike the state parliaments, which can actually legislate on anything, okay, so there is no limit to what the state parliaments can legislate, except insofar as they may conflict with the legislation passed by the Australian Federal Parliament, or to the extent that the Constitution clearly provides that the state does not have the power to legislate in that regard. As a general rule, state parliaments can legislate on anything except that which the Constitution has exclusively reserved to the Australian Federal Parliament, or to the extent that there might be legislation passed by the Australian Federal Parliament that would be inconsistent with the state parliament's legislative power. So there's a limit. On the other hand, it's different in the case of the Australian Federal Parliament because it can only legislate on matters or in respect to laws for the peace, order, and good government of the Commonwealth with respect to those issues or subjects that the Constitution provides. Beyond that, the Australian Federal Parliament is not in a position to legislate. So you can see the distinction, therefore, in terms of the legislative power between the Australian Federal Parliament and that of the states. Now, a third aspect of legislative powers is that although we say that we generally think that on the basis of the principle of territoriality in international law, we would assume that a state only has the power to legislate within its territory, meaning, it is quite in fact logical and quite easy to understand why that is so. Australia, the Australian Parliament should only be able to pass laws in general that affect people within its territory. It would be quite curious to say that Australia passes a law and it affects Americans, for example, obviously living in the United States, or Americans living in New Zealand or living in Asia. That would be unthinkable, because there is no such nation with such powers whose laws, in a sense, bind people or citizens of other nations. So on the basis of the principle of territoriality, logically we would assume that the power of a state, or the power of its legislature, should only be applicable within its territorial boundaries, and that is a clear principle of international law. However, there is such a thing as the principle of extraterritoriality, where it is actually within the power of the Australian Parliament, or the legislature of any state for that matter that is sovereign, to enact legislation that affects its citizens even if they are outside of its territory. So there is no constitutional prohibition, there is no legal infirmity in the idea that the Australian Parliament passes legislation that affects its citizens or residents outside of Australia. So if it's possible for the Australian Parliament, for example, to say that a person who might commit pedophilia, let's say in Thailand or in the Philippines, even in the Philippines, that will still constitute a crime, and they can be subjected to the criminal processes of Australian courts, even if they actually committed the crime abroad. It may also say that an Australian citizen who joins the war against the ISIS in the Middle East, or who commits atrocities outside of Australia in the course of the problems in Iraq or Syria, that they are still subject to the criminal laws of Australia. Those types of legislation would be valid and constitutional under the principle of extraterritoriality. But again, as I said, they are only limited to the actions or to the acts of Australian citizens or Australian residents. Now, it is also possible, as we will later see, especially in the case of Poljukovic, that a person who was initially not an Australian citizen or not an Australian resident, who might have committed an atrocity abroad, or who committed a crime against humanity abroad, and then became an Australian citizen or an Australian resident, it would be possible in that particular regard for that person to be the subject of a law that makes it a crime for him to have committed atrocities or crimes against humanity in another country, even at the time when he was not an Australian citizen or an Australian resident. And the clear case that I mentioned here is the case of Poljukovic. And although you might begin to think, how could it be possible that somebody who committed a crime before the law was actually enacted, and more so, a crime committed outside of Australia, how can that person be the subject of the criminal processes or the application of Australian laws? How can that be possible? And in relation to part one, as I said, is the principle of extraterritoriality, that it's possible for the laws of a nation to extend beyond its territories, to subject its own citizens or residents to its own laws. And in relation to the question of how can it be possible that a crime that had been previously committed can actually become the subject of a crime in Australian law. So meaning, for example, if somebody committed a crime in, let's say, year 2005, and then the Australian Parliament passes a law in 2015, criminalizing that particular act or behavior that occurred in 2005, how can that be possible? That seems to be anathema to the notion of the retrospectivity of legislation. How could that be possible? And as we will later see in later weeks, the principle of the principle against the retrospective or retroactive application of laws does not really apply in Australia, and that was clearly identified and stated by the High Court in the case of Poljukovic. And the main reason why this is so is that, and in that particular case, the High Court canvassed specific examples, especially in the U.S. and other countries where the retrospective application of laws is anathema to a constitutional government. In Australia, it's totally different because we do not have a Bill of Rights. And usually in a Bill of Rights, if there were a written, if there was a written document that set out, or if there were a written constitution that clearly set out what the rights of citizens and residents might be, typically in the case of the United States, for example, or in the case of the Philippines, they would identify or they would state that laws cannot have a retrospective effect. But because we do not have a Bill of Rights in Australia, the High Court pointed out that the examples or the practices in the United States, for example, cannot apply to Australia. Okay, so let's move on. Now, the other aspect of legislative powers is that it is permissible for the legislature in enacting legislation to actually be biased in the exercise of its powers. So it actually discriminates. It can favor or disfavor a group of people. And in that case, if you look at taxes, for example, it's essentially discriminatory because there are various tax rates depending on the kind of income that an Australian citizen or resident is earning. Wouldn't that be discriminatory? You might wonder, why would it be that somebody who's earning more money gets taxed more and those who are earning less gets taxed less? Isn't that a form of discrimination? Or you might say that wouldn't it be discriminatory that the access to government benefits is means tested? In other words, certain people in Australia are not entitled to Centrelink benefits because they have more money than others. Isn't that discriminatory as well? So let's be clear that it is in fact part of the power of any legislature to specifically discriminate. It's so difficult to think that every single law will necessarily be applied equally to all. I mean, in the sense that for as long as there are clear distinctions between classes or groups of people, then a parliament is free to provide distinct and disparate legislation that affects these various groups of people. Now, I also wish to point out that in that case, it's also possible, for example, for the Australian Parliament to discriminate according to gender. So it may, and again, men may complain. It may mean that they provide further protection to women as opposed to men, and it's interesting because yesterday I was at court and I came across a group of people. They are part of the section, I think it's called the Group of 21, and this is a group of fathers who are trying to bring to the attention of the Australian Parliament the fact that 21 Australian fathers commit suicide in Australia each week. Let me repeat that. This group of people, which I found very interesting when I was at the Federal Circuit Court yesterday, I saw them, trying to bring to the attention of the public the fact that in Australia, 21 fathers commit suicide each week. Think about that. And when I asked them about it, they said that the statistics were derived from data available from Griffith University. I haven't had the chance to actually look into the accuracy or veracity of the data, but let's assume that to be true. The reason why they formed this group was that they were saying that in Australia, fathers are marginalized. It is very difficult for fathers to actually win custody over their minor children, so that there is a predisposition, a favoritism on the part of the Australian Parliament to favor mothers, so that, if in relation to custody over young children, the laws tend to favor mothers. So that clearly would be an example of a very partial, a very discriminatory exercise of legislative power. And it raises the question, isn't that anathema, again, to a constitutional government? And the answer is no. Typically, the legislature in general, and we're talking of general principles of constitutional law here, it is permissible for any legislature or the Australian Parliament to discriminate across classes or groups of people for as long as across groups of people the discrimination might be said to be reasonable, and it's at the same time they are proportionate to the aim of the legislation. Now, I will not go into the details about that yet because that will be the subject of a discussion later on in coming weeks. Now, at the same time, we might say again, in relation to the judicial power, the judiciary, in exercising its power, is never permitted to discriminate. In fact, it is a key pillar of the principle of natural justice that a judge or the one exercising judicial power must always be impartial and cannot discriminate. So that you will see the clear distinction between the exercise of powers by the legislature versus the judiciary. The executive also is in fact clearly can also discriminate. There's nothing wrong with that because the executive has no choice, but at least in terms of articulating what the policies should be or what the national agenda should be, it has no choice but to determine how rights and how certain benefits may actually be distributed in the population. And so moving on, the legislature also has the power to articulate and create policy. So it is to them given the power to establish rules and policies, let's say on climate change, same-sex marriage, education, and welfare benefits. So it is not for the courts to articulate and create policy. I think there was a question that was posed some weeks back during one of our tutorials where the question that was asked was, does the judiciary actually create policy? Because as I pointed out, it is Parliament that creates policy, and by extension, it's also the executive actually that creates policy. Does the judiciary actually create policy? And the answer is, broadly, the answer is no. Okay, so let's be clear. In general, the judiciary has no power to create or articulate policies for the nation. Are we clear about that? As a broad principle. However, in truth and in fact, especially in common law countries, because the rule is, judges will not adjudicate an actual controversy or will not refuse to exercise its judicial power simply because of the absence of statutes or statutory enactments. Judges in common law countries will still adjudicate and come up with a decision involving an actual controversy. And in those instances where there is no law that will cover the field that is the subject of an actual controversy, the judges will have no choice but, they may end up creating policy as a consequence of the absence of the legislature passing laws on that subject. And for example, and so the other aspect is it may actually create policy in the sense that it may say that it is unconstitutional, for example, for a specific for a legislature to enact same-sex marriage legislation, or something that makes access to education, universal education, very difficult for those who do not have money. And if the judiciary were to, I'm speaking broadly, if the judiciary were to strike those down as being unconstitutional, in doing so, the judiciary is actually creating policy. Okay, so those are just specific examples. But again, we will look into that in detail as we move on. Now, let's speak of federal state legislative powers. I already mentioned that the power of the Commonwealth is narrower in the sense that it can only just legislate on subjects that are clearly provided in the Australian Commonwealth Constitution. Beyond those heads of power or beyond those subjects, the Commonwealth Parliament cannot legislate on it. In contrast, states have plenary power to legislate on anything and on everything except that which has been exclusively reserved to the Australian Commonwealth Parliament. So let me repeat. The state parliaments, because as a part of the historical creation, because remember, prior to the Australian Federation, state colonies actually had the power of the UK Parliament. So in the UK, the UK Parliament is supreme in the sense that no UK court can actually declare a law of the UK Parliament to be unconstitutional or invalid or illegal because of the principle of parliamentary supremacy. And prior to federation, when the colonies were created, for example, in the colony of New South Wales, the rule was that the state parliaments had the same powers as the UK Parliament. And so, in that case, because as a vestige of that historical fact, state parliaments have plenary power to legislate on anything and of everything for as long as it is within their state or within their state territorial boundaries, except on those which have been expressly reserved by the Constitution to the Commonwealth Parliament. Okay. Now, let's speak of the. Hold on. So going back a bit, there are also, however, subjects which actually fall within, which are the same subject, the subject of legislative power by both the Commonwealth and the State Parliament. It is shared. So, in other words, both the Commonwealth and the State Parliament within its territorial limits may legislate on such subjects as crimes, marriage, trade and commerce, banking, insurance and bankruptcy, and so on. However, the rule under Section 109 is that once the Australian Federal Parliament has legislated on a field, any law that state parliaments have previously passed will be declared unconstitutional to the extent of the inconsistency with federal legislation, and neither will state parliaments be permitted to legislate on that same field that is inconsistent with the federal legislation. So that's under Section 109. Now, let's move on. The executive power. So obviously we know that the executive power involves a duty and the power to execute and maintain the Constitution and the laws of the Commonwealth. And we will later see what this actually means, but so we will look at the dimensions, but at the same time, we will also notice later on, and this is what we're doing in the lecture podcast, we will also see that the executive power often involves the exercise of quasi-legislative and quasi-judicial powers, in the sense that they are sort of legislative powers and sort of judicial powers. And we're going to go into detail in a short while. So let's examine what the executive power typically consists of. So the executive power, as we know, involves the police power. So that provides for the peace and order of the state or the nation, or in the case of Australia. So that's the running of the police. It ensures that laws are executed and that people can be arrested. So that's part of the executive power. The military power as well. The defense of the Commonwealth. The power to head the military, the power to determine whether Australia should go to war, that is part of the executive power. There's also the foreign affairs power, that it is within part of the executive to enter into relations with other states, enter into treaties, enter into diplomatic relations, enter into commercial relations. That's part of the executive power. It also has the power to enter into contracts. Now, the key thing we need to point out is that, especially in the case of Australia, much of what we call to be part of the executive power are actually not in the Australian Constitution. They have not been specifically provided for in the Constitution, but it is inherent. It is considered inherent for these powers to exist as part of the executive power. In other words, as part of the basic power of the executive to execute and ensure the fulfillment of laws of the nation, it must necessarily have the police power, the military power, the foreign affairs power, and the contracts power. The military power obviously is in the Constitution itself, but for other powers, especially the foreign affairs power and the contracts power, it is an inherent part of the executive power to be able to undertake these specific powers. So these are residual powers of the executive, and they do not require any statement in the Constitution. However, it should be pointed out that the exercise of the executive power may actually be subject to legislative control through legislation to one extent. Okay, so in other words, the Australian Parliament may decide to pass legislation um, on the scope of commercial relations with other nations, or may try to define uh, aspects involving the international activities of Australians. And in that case, that will be a clear constraint on the executive power as well. Now, so moving on. Now, speaking of the quasi-legislative powers of the executive, there are actually two aspects to this. One is the notion of the power of the executive to enact, laws or rules that affect the people in general, both as a result of a delegated power by Parliament, and both as an inherent or a residual power of the executive power. So let's speak of the second part first. So you will notice that the executive government may typically pass regulations or rules or policies or procedures that affect the people in general. And oftentimes this could be about the way the issuance of licenses, or rules pertaining to the collection of garbage and so on, even at the federal level, for example. But in those specific instances, there might not be any legislation that actually authorizes the executive government to enact rules in those subjects. Does it mean that that is invalid? The answer is no. It is an inherent power of the executive to promulgate rules that affect the nation, for as long as it is a necessary consequence of the exercise of its executive power, subject of obviously to the to the to the right or the power of the legislature to delimit or to control or to regulate that specific subject. Now, the other aspect is the notion of subordinate legislation. And when you speak of subordinate legislation, and I'm focusing on the word subordinate or inferior legislation, it's called subordinate or inferior legislation. These refer to rules, policies, and procedures that are enacted or written or drafted or crafted or created by the executive government as a result of delegated authority by the legislature. They are considered subordinate because those specific instruments or procedures or policies passed by the executive government are subordinate to and must be compliant with the enabling law passed by Parliament. In other words, if there is a conflict between that which has been enacted or created by the executive government, if that is in conflict with the enabling law passed by Parliament, that the creation of the executive government will be declared invalid. So in other words, if the executive government passes certain rules or regulations affecting the people on the basis of an enabling act passed by Parliament, those executive instruments must comply or must be according to what the enabling law states. And in case of conflict, it will be the enabling act or the law passed by Parliament that will govern. And it also means that if the executive passes or crafts certain instruments or policies or procedures or regulations that are beyond that stated in the enabling act passed by the Parliament, that will be considered as an ultra vires exercise of delegated authority. Now, there are two important cases here that recognize the legality, the validity, or constitutionality of delegated authority. The first is the case of Australian Communist Party versus Commonwealth. And in that case, the High Court said that it is well established that the so-called separation of powers under the Constitution does not preclude the Parliament from authorizing in the widest and most general terms subordinate legislation under any of the heads of its legislative power. So for as long as the delegated authority is on a subject that the Australian Parliament is permitted under the Constitution to legislate on, it is permissible for the Australian Parliament to authorize the executive to create subordinate legislation in that regard or under that specific head of legislative power. What it also means is that the Australian Parliament cannot authorize the executive to pass subordinate legislation on an area of law or a head of or a specific subject or a field of law that is not within the power of the Australian Parliament to legislate on. So this is based on a Latin principle of delegata delegare non potest delegata. What it means is that one can only delegate power that one has, and one cannot delegate power that one does not have, which seems to be quite logical. So the power of the Australian Parliament to authorize or empower the executive to create subordinate legislation is limited to the scope of the heads of legislative power as stated in the Australian Constitution, especially in particular Section 51. The other important case in relation to quasi-legislative powers, so that was clear, right? So the other crucial case is the case of Victorian Stevedoring and General Contracting Company Proprietary Limited versus Dignan, or what is typically called the Dignan's case in 1931, where the High Court said that it is very difficult to maintain the view that the Commonwealth Parliament has no power in the exercise of its legislative power to vest executive or other authorities with power to pass regulations, statutory rules, and bylaws, which, when passed, shall have full force and effect, unless the legislative power of the Parliament extends this far. Effective government would be impossible. Now, let's move on to the notion of quasi-judicial power. So, when we speak of quasi-judicial powers, we're saying that the executive is exercising certain powers that have the semblance of judicial powers. And that is because they're quasi-judicial because the people that exercise the so-called quasi-judicial powers attempt to act judicially. So they're acting like judges. And if when you think about the notion of a judge, what exactly is the character, or what are the key characteristics of a judge? We know that legislators and the executive, it's okay for them to be biased, to be discriminatory. And you might say that the executive and the legislature can often act in ways that are considered unfair. I mean, the example I gave earlier was the group of 21 fathers who felt that the stakes were stacked against them, so that in case of doubt, all things being equal, they would say it would be mothers who would gain custody over children, and that seems to be the state of Australian law. But the question is, would it be okay for the judiciary? I mean, when you think about it, is it okay for the judiciary or the judges to be discriminatory and to be partial and play favorites? And the answer obviously is no. It is a basic tenet or a basic characteristic of the judiciary that it must be impartial, which is why you would often say that, justice is blind, or, the picture of the image, think of that image of Lady Justice carrying a scale. It balances interests, but it always seeks to be fair. And so when you say that it's quasi-judicial, it means that certain persons within the executive government are trying to act judicially, which means that they function according to the rules of natural justice and procedural fairness. And there are at least two components to this when they attempt to act judicially. One is that they have to be impartial, they have to be fair, they cannot discriminate. And secondly, they must give people or the people who are in a proceeding before them the opportunity to be heard. And typically, quasi-judicial power would often be seen in the context of administrative tribunals, okay, where these tribunals, although they are not part of the judiciary because they do not exercise judicial powers, and I'll have more to say about that in a short while, they are required by law to act judicially. And so oftentimes these administrative agencies or administrative tribunals are created and operate on the basis of subordinate legislation, meaning legislation, these tribunals operate on the basis of primary legislation, or in other words, enabling legislation passed by the Commonwealth Parliament. Now, one of the key differences is that why they are also quasi-judicial is that in the case of the judicial power, as we will later see, judicial power is typically, is exercised only in instances where there is an actual controversy between parties involving the violation of certain rights or the imposition of certain duties or liabilities or the exercise of certain duties. But when we speak of the exercise of quasi-judicial powers by the executive, we will often see that the executive has the power to unilaterally and coercively change legal relations. So in other words, even if there is no specific law or rule in a case that is before a tribunal or an executive agency trying to act judicially, it can change or alter legal relations, even create new relations. On the other hand, the exercise of judicial power must always be according to what the law says. And obviously, when I say what the law says, it doesn't have to mean that what the law says in the context of laws passed by Parliament, because as I said, in the context of common law countries, judges, as they are often called, lawmaking judges, they often create laws in the sense that where the legislature has failed to enact laws in a specific field, judges fill the gap by stating what the law should be. Okay, but again, when they say what the law should be, they are reliant on an existing law, even if that law seems to be ancient or historical. But in relation to the exercise of quasi-judicial powers by the executive, the executive in that case tries to create new laws or tries to create new rules that apply to people. And this is easily seen in the context of the review or issuance of licenses by the executive, or when they authorize or give approvals in relation to what citizens can do. Now, moving on to judicial power. Let's see. So we've covered that so far. The judiciary, as we saw earlier, we saw that the judiciary was quite happy to welcome a blurring of the lines between the executive and the legislative divide, so that it is even permissible for the legislature to authorize Parliament to pass subordinate legislation, so making them quasi-legislative. And we also saw that it is permissible for the executive to have exercise quasi-judicial powers. Now, however, in relation to judicial powers, meaning the powers exercised by, and we're speaking, remember, of the federal courts here, the judicial power, the High Court has clearly pointed out, it can only be vested in. So we're speaking of federal judicial power. Federal judicial powers can only be vested in what are known as Chapter 3 courts. So the High Court will not tolerate the exercise of a judicial power by the executive or by the legislature. So in other words, if there seems to be an administrative tribunal or an administrative agency, meaning administrative in the sense that they are part of the executive department, if these tribunals or agencies attempt to exercise judicial power, that will be deemed to be invalid and unconstitutional. So when there is an administrative agency, for example, under the executive department that seeks to govern an actual controversy between parties or the exercise of judicial power in that regard, that will be struck down by the federal judiciary as being unconstitutional and invalid. Now, the other aspect that the High Court has been very guarded in is in relation to the authorization or the vesting of non-judicial powers on Chapter 3 courts. So while the High Court has recognized that it is okay for the legislature to vest quasi-legislative powers in the executive, the High Court will not tolerate the vesting of quasi-legislative powers on the judiciary. It will not allow that. And so on those two aspects, the judiciary has been quite guarded. And one of the first cases that is crucial in this regard is the case of Victorian Stevedoring and General Contracting Company Proprietary Limited versus Dignan, or Dignan's case, which we earlier cited, where the High Court said, and specifically Justice Dixon said, because of the distribution of the functions of government and of the manner in which the Constitution describes the tribunals to be invested with the judicial power of the Commonwealth and defines the judicial power to be invested in them, the Parliament is restrained from both reposing any power essentially judicial in any other organ or body and from reposing any other than that judicial power in such tribunals. The High Court also stated in R versus Kirby, or the Boilermakers case, that the existence in the Constitution of Chapter 3 and the nature of the provisions it contains makes it clear that no resort can be made to judicial power except under or in conformity with Section 71 to 80. And Section 51, subsection 39, also extends to furnishing courts with authorities incidental to the performance of the functions derived under or from Chapter 3, and no doubt to dealing in other ways with matters incidental to the execution of the powers given by the Constitution to the federal judicature. So in the Boilermakers case, what it essentially means is that the judicial power includes incidental powers that may not be specifically provided in the Constitution. And the High Court also said that for that reason, it is beyond the competence of the Parliament to invest with any part of the judicial power, any body or person, except in a court created pursuant to Section 71 and constituted in accordance with Section 72, or a court brought into existence by a state. And then I'll speak shortly about how it is in the states. So judicial power has two key elements. One is that there must be an actual controversy involving rights to life, liberty, or property. So in other words, if there is no actual controversy, in other words, if it involves something that's hypothetical or theoretical or a potential scenario, the judicial power cannot be invoked. So the judicial power can only be invoked when there is an actual controversy involving rights to life, liberty, or property. Um, it's important to emphasize this as well because if you remember in the previous week, we talked about the case of the dismissal of the government of Prime Minister, the government of the former Prime Minister Gough Whitlam by former Governor General Sir John Kerr. And in his letter dismissing the Gough Whitlam government, former Governor Sir John Kerr said that he was acting actually on the advice of the former Chief Justice of the High Court. I think, if I'm not mistaken, it was Chief Justice Barwick, who said that the Governor General had residual powers to dismiss a Prime Minister who refused to resign even when he had lost the confidence of Parliament, or refused to resign even when he was unable uh, to pass supply legislation. And he had actually cited, former Governor General Sir John Kerr had actually cited the the advisory opinion of Chief Justice Barwick in that regard, in saying that in those instances when a Prime Minister loses the support of Parliament or is unable to pass supply legislation, the Prime Minister in that regard has only two possible choices. One is either to resign or to call for general elections. And in those tumultuous years of on those in 1974 and 1975, the former Prime Minister then, Gough Whitlam, had said that he was neither going to resign and neither was he going to call for general elections. And Chief Justice Barwick of the High Court said that it was within the power of the Governor General, the inherent or residual powers of the executive of the Governor General, to dismiss the Prime Minister. So that was an advisory opinion. And it is clear that if you follow Huddart Parker and Company Proprietary Limited versus Moorhead, the High Court has clearly, the High Court itself, the court itself, not just the Chief Justice or not just a single justice, the High Court has pointed out that the exercise of judicial power can only be made when there is an actual controversy. The High Court cannot provide a hypothetical opinion or cannot try to adjudicate or provide a decision on the basis of a theoretical controversy, which wasn't the case because there was an advisory opinion provided by Chief Justice Barwick. But again, that was in the context of the difficult years of 1974 and 1975. And I don't think that there was ever, well, although Sir John Kerr relied on it, there was never any attempt to say that the advisory opinion was ever binding. It was meant to be actually advisory. But again, in general, it is not for the judiciary to provide advisory opinion. Secondly, the other aspect of the exercise of judicial power is that the exercise of the judicial power must be binding, and it must be authoritative. Binding in the sense that it actually compels the performance by those involved in a controversy, that they must do or not do certain things. And it is authoritative in the sense that it actually binds and is conclusive in relation to the matter or subject that is the basis of a controversy. When we speak later on, when we speak of being authoritative, it doesn't mean, or when we speak of it being binding or conclusive, it doesn't mean that a decision made, for example, by the Federal Circuit Court becomes final. It can actually be subject to appeal, whether to the federal court or to the High Court. But it is binding, at least in the sense that if there is no other remedy that is sought to be followed by parties in a controversy, then that decision then becomes the final decision and is binding. Okay, now the other crucial point that we need to cover when we speak of the judicial power is the notion of the persona designata. And this essentially means that what about those instances where Parliament passes legislation whereby a member of the judiciary or a member of the Chapter 3 court is asked to undertake acts that are not judicial in character, meaning the member of the judiciary may be asked to do certain executive functions or administrative functions or even legislative functions, in the sense that a member of the judiciary or a member of the Chapter 3 court may be asked to create reports for the executive or for the legislature, or they may be asked to serve in administrative tribunals, tribunals that are not Chapter 3 courts and that are in fact part of the executive. Would there be something invalid or unconstitutional in that? Because we already said that the High Court has always been very guarded about the exercise of judicial powers, and the High Court has clearly said that no Chapter 3 court can be invested with non-judicial powers by the legislature or by the executive, and the Chapter 3 courts can only exercise judicial powers. That has been clear. So what then do we make of instances when the legislature says that a member of the judiciary or of a Chapter 3 court or of a federal court can exercise certain legislative powers or quasi-legislative powers or quasi-executive powers, or serve in a tribunal that is not a Chapter 3 court? Would that be unconstitutional? And the answer is no, if certain conditions are met. And the idea of persona designata was recognized in the case of Drake versus Minister for Immigration and Ethnic Affairs, where the High Court said that there is nothing in the Constitution which would preclude a justice of the High Court or a judge of this or any other court created by the Parliament under Chapter 3 of the Constitution from, in his personal capacity, being appointed to an office involving the performance of administrative or executive functions, including functions which are quasi-judicial in their nature. Such an appointment does not involve any impermissible attempt to confer upon a Chapter 3 court functions which are antithetical to the exercise of judicial power. Indeed, it does not involve the conferring of any functions at all on such a court. So, in the case of Drake versus Minister of Immigration and Ethnic Affairs, the High Court said that it is permissible for a person, for a judge of who is part of the federal court, to exercise administrative functions for as long as that exercise is the exercise of by him or her as a person and not acting as a part of the court. That is permissible. And the case of Grollo versus Palmer and Huddard Parker and Company Proprietary Limited versus Moorhead also establish the requirement that the only time when a federal judge or a member of a Chapter 3 court can exercise quasi legislative or quasi executive powers must be based on two conditions being met. One is that there must be consent on the part of the federal judge. So if the federal judge refuses, he cannot be forced to do or to exercise quasi-judicial or quasi-legislative or quasi-executive powers. He cannot be forced. But if he agrees, then that is fine. And that is the reason why we will notice that the head of the Administrative Appeals Tribunal under the Administrative Appeals Tribunal Act 1975 Commonwealth, the head of that tribunal, of that administrative body, is actually must have to be a member of the Federal Court of Australia. It's a requirement. So, but that is based on the consent. The federal judge must consent. And secondly, it is crucial for a federal judge who is undertaking quasi-legislative or quasi-executive or quasi-judicial functions that the performance of those tasks must not be incompatible with the exercise of his judicial duties. In other words, at the very least, a federal judge exercising non-judicial powers, number one, must not be beholden to the executive. So in other words, the federal judge must still be able to exercise independence he cannot become an instrument or a tool of the executive. He cannot act at the behest of the executive, because otherwise that will put into disrepute or put into question the independence of the judiciary. That will not be allowed by the High Court. The second aspect of it is that the federal judge who is exercising non-judicial powers on the basis of persona designata cannot become involved in the sense that he tries to play favorites with the executive, in the sense that his action, he only acts on the basis of trying to please the executive because of the possibility that he may lose certain emoluments or certain benefits given by the executive. In that case, if he does so, that again will be incompatible with his judicial role. And in the case of Grollo versus Palmer, and I'd like to read the statements by Chief Justice Brennan and Justices Dean, Dawson, and Toohey. The incompatibility condition may arise in a number of different ways. Incompatibility might consist in so permanent and complete a commitment to the performance of non-judicial functions by a judge that the further performance of substantial judicial functions by the judge is not practicable. It might also consist in the performance of non-judicial functions of such a nature that the capacity of the judge to perform his or her judicial functions with integrity is compromised or impaired, or it might consist in the performance of non-judicial functions of such a nature that public confidence in the integrity of the judiciary as an institution or in the capacity of any individual judge to perform his or her judicial functions with integrity is diminished. So I would also invite you to just read the case of Hilton versus Wells, which affirms the same statements made by the High Court in the previous cases that I mentioned. And finally, let us look at the case of the separation of powers in the Australian states. What is important to realize is that unlike the Australian Federal Parliament, which can only exercise federal legislative power as that clearly provided for in the Australian Commonwealth Constitution. So in other words, the Australian Federal Parliament is limited to legislate on those fields or heads of power that are specifically mentioned in the Australian Constitution. When it comes to the Australian parliaments, on the other hand, the Australian state parliaments can legislate on anything and on any subject. No, there is no limit to what they can legislate on, except as limited by the Constitution. So the limit of the plenary power of state parliaments to legislate is that which is provided for in the Constitution. And that is on the basis of the notion of state parliamentary supremacy. So they can legislate on anything and on every subject for as long as it is not limited by the Constitution, and secondly, that power is limited within the territory of the state. So the case, for example, of Farden versus Attorney General is a statement, the principle, according to Justice McHugh, that the doctrine of the separation of powers derived from chapters 1, 2, and 3 of the Constitution does not apply as such in any of the states, including Queensland. Okay, so what it means is the notion of separation of powers is inexistent to an extent in states. And that is because, as I mentioned earlier, states, unlike the Federation, when states were created, they were remnants of the powers of the UK legislature. And it is a crucial point that the UK legislature actually, as we said, in the Westminster Parliament type of government, there is no separation, or there is a blurring of the lines between the executive and the legislature. But more importantly, the UK legislature, especially the House of Lords, actually acts as a court in the House of Lords. So the House of Lords is a court in the UK system, and because the colonies then, which became later on became states, had the same powers as the UK Parliament, there was clearly no separation of powers. And for that reason, it is permissible in the case of states for courts, in relation to courts, to be vested with non-judicial powers, which is a practice that is repugnant in the federal judiciary. So there's wide latitude in the case of state parliaments to vest its state courts with non-judicial powers, and there is nothing that would be wrong with that. Okay, so there is no separation of powers in states. So that should be clear. The separation of powers is only practiced at the federal level or the level of the Commonwealth. And as I pointed out, that in regard to the plenary power of the states to legislate on anything, in Pierce versus Florenca, the High Court said that it has been established by a series of well-known decisions, which are collected in Cobb and Company Limited versus Crop, that within their limits, the legislature of states have powers as plenary and as ample as those of the imperial legislature itself. So imperial referring to the UK imperial legislature. And in Egan versus Willis, Justice McHugh also said that well before the passing of the Australia Acts, the legislatures of states had plenary powers. Justice Kirby in that case also said that it must therefore be apt to an independent legislative body which enjoys under that constitution plenary powers. So plenary legislative powers. So it can just about, legislate on anything. And because of the supremacy of state parliaments, they can generally pass any law which state courts are powerless to invalidate. So state courts cannot invalidate state legislation on the basis of the principle of parliamentary supremacy. Just like UK courts and New Zealand courts, their courts cannot invalidate laws passed by their state parliaments. However, state courts can invalidate legislation of states if they are repugnant to the Constitution. So that is the limit. State parliaments can pass any law for as long as they do not violate provisions of the Australian Constitution. So, also as I said, although there is no separation of powers in states, it is crucial to point out that while separation of powers is not judicially recognized in states, the High Court has pointed out that there are, however, limits to the idea of state legislative state legislative power. And one of those limitations is that one, and this is on the basis of the case of Cable versus Director of Public Prosecutions, New South Wales, so the Cable case in 1996, the High Court pointed out that there are limits to the state parliamentary power. One is that, so obviously they cannot go against the Constitution, but more than that, the High Court said that states must each maintain courts, or at least a court for the exercise of the judicial power of the Commonwealth. So even in states, there must be a court that must exercise judicial power of the Commonwealth, and that is because of what is provided in the Constitution, that there are state superior courts. Two, state parliaments cannot legislate to confer power on state courts which are repugnant to or incompatible with their exercise of the judicial power of the Commonwealth. So in other words, when a state court is exercising federal or Commonwealth power, then the exercise of state or meaning the exercise of federal judicial power must not be incompatible with uh, any other quasi-judicial powers that a state court is exercising. Yeah. It also means that um, a state cannot abolish its courts and set up a system of tribunals that were not courts. A state cannot abolish its Supreme Court, and state parliaments cannot legislate in any way that might undermine the role of state courts as repositories of federal judicial power. So, in other words, if state courts end up not following the rules of natural justice, or they end up becoming tools or instruments of the executive or the legislature that will undermine their exercise of federal judicial power, and state courts exercising federal jurisdiction must be perceived to be independent of the legislature and the executive government. And in South Australia versus Totani, the High Court said that established in the case of the Magistrates Court, established as a court by the state, the Magistrates Court cannot be deprived by the state of those minimum characteristics of the institutional independence and impartiality identified in the decisions of this court. And what it also means is that therefore, because of the absence of the principle of separation of powers at states, it is permissible for state courts in general, therefore, to be vested with quasi-legislative and quasi-executive powers, a state of affairs which would not be tolerated in federal courts, but subject to the limitations that they must be independent and that they are not tools of the executive or the legislature. It is permissible for state parliaments to invest state courts with quasi-legislative and quasi-judicial functions. So on these basis, with these lecture podcast, I hope that after you would have studied this topic, you should be able to therefore distinguish and explain the operation of separation of powers at the federal and state levels, explain the weakening of the division of powers between the legislature and the executive, and the permissibility of vesting quasi-legislative powers in the executive, explain as well the guardianess of the High Court against any encroachment into federal judicial powers, explain the concept of judicial power in relation to the High Court's strong resistance against the vesting of non-judicial powers on Chapter 3 courts, and discuss and cite key judicial decisions that elaborate on the separation of powers. So thank you for listening to this lecture podcast.